All right, good evening, everyone. Please, can someone confirm that they can hear me? Good evening.
I can hear you.
All right, thank you, Victoria. Good evening once again. Welcome to today's class. This is the fifth week of our mentorship program of the JIIPCC mentorship program. It has been an interesting journey so far. We're coming from week one, week two, week three, week four, and now we're in our week five, right? And I'm sure so far the journey has been very interesting, very exciting. The classes have been something you have been able to pick maybe one or two things from, and you've been able to learn quite a lot on the alternative dispute resolution space. Our mentors have, in the last few weeks, done their very best to make sure that they've run with us and taking us through, well, basically, maybe not everything, but the key concepts, what you basically need to know about um, alternative dispute resolution. And in the last 2 weeks, we've had um, not just the a theoretical aspect to it, but also a form of practical to it. Last week we had practicals and mediation simulation. This week we'll be having practicals and arbitration simulation, and I trust that both Group One and Group Two are ready to make their simulations for this week. I'm sure our mentors will soon be joining us on the call. Yes, Mr. Nelsham is already with us. I'm sure they will be here to make sure that we have a very interesting interaction in today's class. So please, I encourage you all to please have your pen and your paper ready, right? Make sure you do your best in your simulations, and I trust we'll have a wonderful session. My name is Dennis Williams, and I'll be your moderator for this class. And I'll be your moderator for this class. Once again, you are welcome to the fifth week of our mentorship and internship program. Still, just basically to still introduce our mentors, right? Our first mentor for today is Mr. Nyacham Namwan, right? Mr. Nyacham Namwan is the executive director of the Settlement House ADR Training Institute. Not to further keep reiterating or repeating his profile, as we are all aware of who Mr. Nyacham is. He's also a very active member on our WhatsApp group. Thank you so much, sir, for joining in. We're always happy to have you with us. It has been so interesting and exciting learning from you, and I'm sure our mentees have been able to pick so much from all that you've had to share in the last couple of weeks. You're welcome, sir. Our second mentor for today is Miss Baratu Johanna Dangana. Ms. Baratu has also been one of the mentors that has been with us coming from week one up to this point. Right, she has been very a key part of our journey so far, and we are happy that she's will be with us in today's session. She's not yet here, but I'm sure she'll be joining us shortly, and we look forward to also just hearing from our mentors and making sure that we have a wonderful class. Our third mentor for today is Mr. Samuel Orobosa or Sarere. He's going to be our third mentor for today. Mr. Samuel, he doesn't need any further introduction. If you've been following through the class, Mr. Samuel has been a key part of our classes coming from week one down to this point. I'm sure when Mr. Samuel joins, okay, he's already here with us. It's going to be an exciting and an interactive and a wonderful session with him around. Our fourth mentor for today is Mr. Idris Mohammed. Mr. Idris Mohammed, he was here with us in week three for our class on arbitration. He will also be here with us for our simulation on arbitration. We look forward to having him also give his insights and his thoughts on the simulations that we'll be having today. I want to say once again a big welcome and a big thank you to all our mentors that are currently here with us on call. We are so happy and so pleased to have you here with us. And not to waste or any further time with introductions, right? We'll just go straight into the business of the day. All right. So Um, with that being said, right, I want to still basically encourage our mentees. I want to encourage our mentees that please you can just do well to reach out to the other members on the group, right? Make sure that you tell your colleagues that class have started. We've officially started class, and our numbers are not so um, are not so encouraging. So please, we would like to have those announcements. Please let your friends know that we've started class, um, so that we'll have a better or a more packed session. So not again, not like I said, not to waste any time. We want to hear from, if both groups are on call, right? We want to receive their simulations. We are ready to receive their simulations. But it seems we just have, I think, two, just 3 or 4 mentees on call. Where's everyone? It seems we are having quite a shortage in the number of mentees on call. Um, please just a minute. Let me try and see if I can put a call to the group so that those who are not aware of the start time can join in. So please, okay, thank you, Ms. Baratu, for joining us. Thank you, Maria. Welcome to today's session. So if group one is ready, please, you can go ahead and start your simulation. I'm sure we'll have quite a number of mentees that will be joining us shortly. So group one, please, if you are here and your simulation is ready, please, we would like to hear from you using the case study from um, using the case study that we used in the previous class. We would like to hear what you people have discussed and what you people have come up with as regards the simulation. So, group one, are you guys ready? Anyone from group one here on call?
So, good evening.
Hello, Mr. Nyasham, sir. Are you trying to say something, sir?
Yeah, good evening.
Yes, good evening, sir. You're welcome, sir.
Thank you. So, today is supposed to be practical for arbitration. Uh, for last week, we were able to do that of mediation, and it was
Yes,
expected
sir.
that participants would have engaged in their discussion in their respective groups, and then be able to present. We have taught. We have taken care of what they need to know in arbitration, some of the things and the steps they need to take, and then now it is for them to put that knowledge into practice. And it was expected that they would have made research, make consultation, visit YouTube channels to find out more, and then come to make their presentation so that we can later on make our input. That is what was expected. So, and you can see now the turnout for the mentees are very low. And I've stated last time, I said we should try and take advantage of the mentorship program, because some of the information that are being passed across are they are information that it will take you a lot of resources to be able to gain. But here are the mentors available for you. Ask any question, get the knowledge that it may take you time to even go through some of the trainings to acquire. So they are there for you. I was expecting that the mentees will actually take advantage of the situation. So in adding my voice to that of Dennis, if you know any of your group member or a mentee that is not yet in, please reach out to him or her and let them know that the session has started and they need to be here as quick as possible for us to begin. Thank you.
Yes, thank you so much, sir, for that, sir. And I trust our mentees. Please, you people should try as much as possible to take what we are doing very serious. The information, like Mr. Nyacha have said, that has been or that is being passed on in this particular program for very little or no cost, is something that if you were to pay for in another setting, you may have to pay almost through your you have to pay like quite a lot. So please, we would like for our mentees to actually be committed to these sessions, as I'm sure what you are receiving is invaluable and you cannot necessarily put a price on it. So if group one is not ready with their simulation, please can we have group two start their simulation so that we can maybe try and see if we can get through to group one maybe later on. So group two, are you ready with your simulation? Do we have group two members here on call? Okay, please, I would just like to
We have,
encourage all. Yes,
we
I
have
can hear you, sir.
who are those that belong to group one?
Please, well, can we have our mentees turn on their video camera, your video, so that we can see, we can have an interaction? Please, can we have our videos turned on?
Video turn on.
All right,
Pending.
Gloria.
Why is it hiding? Okay, just come on.
So please, group one mentees, please, if you are here and you are in group one, please, we would like to hear from the group. What have people come up with as regard the simulation for this particular class?
Um, we took care of last week. Good evening, sir. Well, thank you so much for everything. We took care of the last week remediation simulation. Then this week there wasn't much persons to have meetings with and all that. So I don't know whether others prepared.
Okay, so if I am getting you correct, in essence, the group did not necessarily do make any significant contribution or do participate to make there was no significant participation to make the simulation ready for this week. Okay. Group two. Can we have our mentees turn on their videos, please? Turn on your video camera. We want to have a brief interaction so that we can have our simulations if they are ready. Um, Group two, please turn on your videos. Can we have members from group two turn on their videos? Okay. Thank you, Victoria. Thank you, Favor. Okay, Mr. Ephraim, thank you. Winner, thank you for complying. So please, since we are having a little issue with group one, right? Is group two ready with their simulation? Ready for the simulation?
Good evening. I
Yes, good evening,
I
Favor.
do not think I do not think aside the tax responsibilities for who is to coordinate the group for the week, aside that message, there was nothing on the group chat to show that there was any preparation for a simulation today. Not at all.
But informations were sent out to the both groups or to the groups stating that you were supposed to coordinate option for the simulations for this week. And I'm very, very surprised that no group was, or in that manner, no group has been able to come up with anything as regards, or was able to do anything as regards the simulation for this week, considering that we had the simulation for mediation last week. So I don't know exactly why this is an issue. Well, seeing that we had the same practical to this last week. So, well, can we just have okay, seeing that people did not have discussions, we'll just to participate in the process. We need volunteers. We still want to have our simulations in class right at the moment. So please, can we have volunteers take up roles, and we will still want to have presentations, the simulation, either ways, whether if the group in itself is ready or not. So please, can we have mentees from right turn on their videos?
Okay,
Please,
I'm
this is
Gloria.
a very serious matter.
I'll take up the company. The company.
Okay. Um, Idris, please, you can also turn on your video. We'd like to see you and know who you will be representing alongside other people. Please, if that will be very, we will need that to happen very quick. People can take up the different roles and just quickly have for arbitration. And while group one is doing that, group two, please also get ready so that we can have those simulation. It is essential that we have this in class because it's a practical session. The mentors are supposed to give feedback on what people have done, right? So it is very important that we have this simulation in class. So can we have more people volunteer so that we can move on with class? Thank you. Idris has already said he'll be joining or he'll be taking. Who else is in group one that would love to take part in the simulation for group one? Okay, no responses. Don't we have group one members here? Joy Emmanuel,
Yes.
if I'm not mistaken, yes. Please, you can step in for your group and so that we can have our simulation. We have Idris, we have Gloria already. I think we need two more people, if I'm not mistaken. Joy, please, you can turn on your video and so that we can start the. Hello, do we have mentees here on call? Please, let's cooperate. Who will be volunteering for the role of the arbitrator for group two, for group one? I mean.
Is it among us that already volunteer?
Yes,
We have. Sorry, please. Who is speaking?
I've taken the company role. The company. A and B company.
Okay, so who is representing Mr. Musa? Joy, what role will you be taking? Are you representing um, the arbitrator or the or Mr. Musa?
I'll present Mr. Musa.
All right. So Idris, please, can you be our arbitrator
Please, can
on
I
this?
have the role played by Mr. Musa so that I can know if I can.
Okay. Idris has Joy. Please, can you
You
be
say,
our
can I be
arbitrator?
our arbitrator, right?
Yes. Go ahead and be the arbitrator. So please, we would like to start. Gloria, Joy, and Idris. So please, on behalf of Group One, you people can start the arbitration session. Please, you have 15 minutes for this. So please, we would like to just have that immediately. And one is having the arbitration session, the arbitration simulation. Group Two, please get ready. All right, please, Mr. Idris, you can go ahead and start.
I think the arbitrator will need to bring us in.
Uh,
Call on the okay.
Yes, Mr. Idris, you can go ahead
sorry,
and
the
introduce.
moderator. I don't really have a brief about what we as we discussed. They are just joined in the middle, so I don't know the role to play. You say as an arbiter, yes, I think I should have a brief before and so that I will know how to moderate on that. So can I have the role to play the brief?
So,
Sorry for accident.
so the case study was sent to the group since last week. So we expect since 3 weeks ago, we expected that every mentee should have
No,
gone through the case study and know the particular
no,
scenario
no, no,
around
no.
it. So please, can we have another person step in
Honestly,
as the
I'm sorry. I don't have any brief about that. I'm sorry. I'm sorry.
Okay, thank you, Idris. Please, can we have someone else step in for the role of the arbitrator? Um, Group one, please. We need someone to step in to serve as the arbitrator. Please, can we have that quickly? Vix, are you a member of Group One?
Yes, I'm a member of
Hello,
Group One.
Victoria.
Yeah, I'm a member of Group One.
Yes. So please can you step in for the role of the arbitrator?
Okay.
All right. So please, we have three people who are going to be conducting the simulation for Group One. We have Victoria, who is going to be stepping up as the arbitrator. We have Gloria, who is going to be represent A&D company, and then we have Joy, who is going to be representing Mr. Musa. So please, Victoria, you can go ahead and introduce the arbitration session, and then we'll now have like to have the opening statement. Please, you're welcome. You're welcome. Please go ahead and start.
My name is Victoria Nwafo. I'm the arbitrator for this session. And I would encourage everyone to let's in their best behavior and to also address each other with respect. And I would like to know each party's name. Um, the representative of the company, please, can I know your name?
My name is Gloria.
Okay. Do I address you as Gloria or is there any special way you want me to address you?
Hmm. Address me as Dr. Gloria.
Dr. Gloria. Okay, my name is Victoria and I would like to be addressed as Victoria.
Okay.
All right. What about the representative of Mr. Musa? May I know your name, please? Seems like he or she is not on the call.
My name is Joy Emmanuel, and I am presenting Mr. Musa.
Okay. Is there any special way you'd like us to address him?
No, Joy is fine.
Okay, Joy. Okay, my name is Victoria, and I would like to be addressed as Victoria for the sake of this. Okay, the reason we are gathered here today is for the arbitration program. I would like to know, has anyone ever been in an arbitration program before, or a session? Have you watched it anywhere? Or have you seen where it's done?
Yes, I have.
And I know you've had your unique experience and you have seen how it is. And for the sake of this session, I would like us to address each other with respect and the way each one pointed out he or she wants to be addressed. I want us to stick to that name or the title, Dr. Gloria and Joy. Thank you. Okay. For the sake of this program, for this session, I would like everybody to have their own turn to talk, and there will be no interruption. And when everywhere is heating up, I would like everyone to cool down, and no one should speak over the other person. And everyone will have their own time to talk. And when the other person is talking, our advice, as this is a virtual session, when the other party is talking, our advice the other party to mute the mic and still leave his or her video on. So you're able to see the person, but the person shouldn't say anything. Thank you. So I'd like us to carry on. I'd like us to carry on. So who are we hearing, please? Are we hearing are we hearing from the company first, or we are hearing from Mr. Musa first?
He starts first. Plans, then the company defense itself.
Okay, you can carry on, ma'am. You can carry on, Dr. Gloria.
I mean that Musa is a complainant. Musa is a complainant. So he starts first.
Okay. Good evening, everyone. My name is Joy Emmanuel, and I am presenting Mr. Musa. My client, Mr. Musa, received or had a job in Abuja, and he was paid 50,000 as his salary. He applied in a company, A and B company to be exact, in Kano, where the salary is 200,000, and he got the job. He received his employment. However, a lockdown was set, and Mr. Musa was told that he would be reached out to during the lockdown so they can see what he's going to do. But the company did not reach out to Mr. Musa, and during the 8 months of lockdown, there was no job, there was no way he could help himself or his family financially, and this caused undue harm and undue damage to Mr. Musa's mental, financial, and emotional well-being in total. So I am here and I'm demanding a sum of 20 million naira as compensation for all the damages, for the emotional, mental, and financial damages.
Okay, Doctor, thank you for your statements, Joy. So, Dr. Gloria, can we hear you now?
Thank you very much. I am Dr. Gloria, and then I'm the secretary to the company. So to speak, I represent the company. I am the company, so to speak. And then Mr. Musa, she's talking, he actually, was employed into our company. And then just in the process of him concluding his documentations and his employment letters and all of that, And at the same time, that was when the lockdown was now imposed by the government of Kaduna State for whatever reason. And so, yeah, within that period, Mr. Musa hasn't even worked. He's never even, entered office once. He was just coming to file his papers and all of that. And yeah, we promised him that we would reach him, okay, because we normally would have to organize a remote arrangement for our workers to still stay at home and do some work, and they will reach him. Okay, we actually reached all of them. I wouldn't know how he did not get the information. Okay, he did not get the information, and according to him, he did not get the information. But according to the HR that is meant to send all the, notes to all the workers, she sent to everybody. And Mr. Musa here is claiming he did not get, and then thereby he did not put in any work. We saw a good resources in him. We saw something good that we needed, for him to use it and then develop our company. But he did not make use of that, and he's now here asking us to pay him, for work he did not do. I wouldn't know where such is done. I wouldn't know how that can be done. And then he, on top of that, he's also asking us to pay compensation. Okay, for which damage? How did we damage him? How did we cause him harm? Okay, so on that regard, I don't think our company is ready to make such payment. Thank you.
All right, thank you, Dr. Gloria, for your statement, for your opening statement. Okay, so I have a few questions to ask both parties. And Dr. Gloria, I'll start with you. You said others got a message through the HR. Can you try to throw more light on that as to why Dr. Musa, why Mr. Musa did not get anyone? Because you left a bit of information out.
Sorry, he mentioned he did not work, and so but we sent information, okay, to workers for remote jobs, but we did not see him engage. He did not engage in any activity, work-related activity for the company. So thereby, invariably, means he did not get information, or he did not, or he got it and refused to partake, and now he's here asking us to pay him. Okay, that's what I mean.
Okay, Joy, I have a question for you. Can you throw more light to us on the damage suffered by Mr. Musa? You made mention of, let's say, emotion. Throw more light on how it affected him emotionally and financially.
Okay, so Mr. Financial breadwinner of his, and he was not able to during the lockdown, which meant it also affected. He faced undue pressure, and he entered into a period of 3 to 5 months. My client, Mr. Musa, said that the contract was valid, the employment valid, and I kept during the lockdown.
Joy, I think we have issue hearing you. We can't hear you clearly.
Hello, Joe, are you with us?
Yes, I'm here. Okay, I'm going to say it again. So my client, Mr. Musa, he is the breadwinner of his family of 5. And during lockdown, he still needed to provide their feeding, clothing, and accommodation. During that period, he could not provide for his feeding a 3 square meal, which his family needed, and his landlord threatened to evict him from his apartment. My client, Mr. Musa, faced undue pressure and fell into a state of depression for a period of 5 months.
All right, thank you very much. And now I have a question for both parties. First of all, I'll go with Dr. Gloria. Was any effort made as to, okay, because you said other employees were also reached out to by the HR, but Dr. Musa was not, Mr. Musa was not reached out to. Was there any effort made by you to still rectify the issue, to reach out to Mr. Musa as regards the issue of the virtual role he was to play?
The responsibility is already given out to the HR, and I have my own section. And the HR confirmed she has already sent the messages to the persons needed to. And it's no longer my responsibility to go looking into individuals. Okay, it's either you would want to partake or you wouldn't want to partake, or probably you didn't get the information, and it's been known to carry out her responsibilities, very well, looking into that.
Thank you. Joy, to you, efforts. Can you hear me?
Okay, I believe that this is negligence on the part of A and B company, because I have submitted evidence that A and B company did not contact me during the lockdown.
Okay. I have a question. Was any effort made by you, Joy, to reach out to them?
No,
based on as
sorry, please.
And Mr. and okay, was any effort made by you, your client, Mr. Musa, to reach out to the company, or did he get any information regarding those who got a mail or who were reached out to?
No, all my client, Mr. Musa, was told was that the company would reach out to him concerning.
So no further effort was made.
No.
All right. Okay, I want to get a clarification on something. You said, Joy, you said Mr. Musa and A and B company agreed on the agreed on the virtual role he was to play. And you, Dr. Gloria, you said the company promised. Can I get clarification on that singular point?
Sorry, please, on what exactly, please?
Okay, Dr. Gloria, when you were making your opening statement, you said the company promised Mr. Musa and others to reach out to them after the lockdown commenced, after the government gave their lockdown ban. You said he promised, and Joy said the company agreed to reach out to Mr. Musa and others. Can I get clarification on that part?
Yes, the company promised to reach out to them. Okay, and then the company, the lockdown just came on, and you need to sit down, draft the letters, and then send out through mail or whatever means. Okay, so the company promised to do that, and I'm sure the company did it. then it depends on who got the message and who did not get, and all of that. So the company promised to reach out, and most of the employees were reached out, and they engaged in the work in remote jobs during the lockdown, except for Musa.
All right. Thank you. So, Joy, you are saying your client is asking, Mr. Musa is asking for a compensation of 20 million naira. And Dr. Gloria, you are saying your company does not owe him anything.
Yes.
Okay. So what's the way forward?
If you ask me, I would say that part, I would leave it for our lawyer to look into it and advise us properly. I am here now as a company itself. Now we need a lawyer to come in and advise us properly on the way forward.
Okay, you need your lawyer to advise you as to that regard. Okay. Does
Yes,
your lawyer
please.
have? Okay, thank you. But you say you're a representative, so you should have should I say you should have the power position here? So why
I said I
seeking
am the
advice from?
company, sort of. No, I am the company. I'm only here to lay the complaint, a kind of marshal out the facts as it is. Now, the company needs the lawyer for advice. When it comes to money, especially when it comes to money and compensation payment like this.
I left out some parts in our arbitral agreements, which says that any party here must have the power to make a decision as regard the issue at hand. That's an omission on my part. So I feel like for the fact that you are here, you should have the power to make a decision as regards the issue at hand.
Final decision?
Joy, can we please hear from you? Okay, she's still here. Joy.
Okay, sorry. My client, Mr. Musa, has said he will not settle for anything less than 10 million. So it is going to be
Anything
between the range of
okay, 10 million. Okay, so you've gone from 20 million to 10 million. So what do you have to say to that, Gloria? Dr. Gloria.
Ma.
Okay, what do you have to say about what Joy said? She said her client, Mr. Musa, would not settle for anything less than 10 million naira.
Well, if you say that I should decide finally here as a company, even though I would have loved our company lawyer to, advise us properly, I would say as a company, if he's asking for a 10 million naira, even when he didn't do anything, you can actually give him, but then with an option of relieving him of his employment. Or give
Okay. Thank you for what you have done thus far. Let me start by appreciating all of you for stepping in and freestyling. I do not actually know whether it was an arbitration session or a mediation session, but everything you were doing were more or less a mediation session. You see, mentees are supposed to have gone, make their research, make their preparations, attempt to do more practicals, so that when they come here, they will now be guided and corrected. I don't know, maybe the mentors.
Hi, Nacho.
Um, okay. Miss Pa, oh great, you're welcome.
How are you? I almost intervened to say we should not allow them be doing wrong procedures, you know.
Yes,
So,
they were supposed to have practiced. It happens that they did not, and so they had to just do something, and then I was wondering what they will, will be doing. And so they started a procedure that is more or less like more or less a negotiation session, devoid of everything. Mentees, if you are serious about learning, because as I told you the other time when we discussed arbitration, one of our senior fellow, a fellow of Chartered Institute Arbitrators, even sent a link of what it takes, or what the cost of becoming an associate of some of these institutes. Miss Pa was here, and she also identified uh, the need for you to belong to an institute, and then the steps you can take to belong to an institute, and then get trained. Now, if you see some of these expenses that are involved, and now you are having the opportunity to be able to learn at the foot of so many mentors who have devoted their time and their attention to be with you, to be able to guide you through the process. I think that would have been a very interesting thing to do. You make your research, make your exercise, or try to practicalize these things, so that when you come, you have an opportunity of being guided through the session. But you see, you have failed to do what you're supposed to do. So the session, how impactful is it going to be? It will be more or less, we are giving you feedback for something you do not do. And if you were able to do what you're supposed to do, and uh, you you made some mistakes, when corrections are coming, it will be fitting properly into some of the mistakes that you have made, and that will make that stay in your mind, in your memory, and you may not repeat such a thing before. But as it stands, you have not made research, you have not conducted the simulation, you have not even met to do what you're supposed to do. So maybe what I think we can do is to give you a step-by-step procedure that you need to follow. Some of the things that you need to follow when it has to do with arbitration, it is entirely different from what you are doing, what you have seen in mediation. It's entirely different. You can describe arbitration to be a week, a semi-court session. We call it a lawyer's. We refer to it as the court without your wig and gown, and with some of the complexities of the rules or procedures, evidence act, and all of those things is devoid of some of those things. That is the procedure. So if you know how the court operates and the procedures in court, they are almost similar. One of our mentors says that arbitration is usually referred to as a private litigation. Yeah. So and then you do not need all of the technicalities of raising objection, this documentation. You cannot take this and that. Private. That is what is supposed to. So I don't know if Mr. Samuel is with us and whether he can speak. But Mr. Idris actually had an emergency. His own father is is not feeling well, and then he has to rush to go and see him. So that's why he's not around. But he says that if the situation comes down, he will join. You can see how committed some of your mentors are to your own development. This is something that you are not paying for, but you have this opportunity, but you are not taking it serious. I wish some of us had such opportunities when we wanted to venture into this field. It would have made a great difference. You have opportunity to ask questions, and different mentors, different opinions, to answer some of the questions and the difficulties you have, but you did not do what you're supposed to do. So for that, it is not a good one. So let me seek the opinion of the mentors that are present. What do you think we should do in the circumstance? Do we conduct a kind of an arbitration, just a kind of ad hoc, sharp arbitration, something for them to see, maybe a procedure to see some of the procedures, just itemize here and there, or we should just give them a kind of teaching or lectures on the procedures, some of the things they need to do. Yes, please, the mentors, let me hear your
Good
opinion.
evening, everyone.
Good evening, sir.
Yeah, good evening to all our mentors. Good evening to the mentees. So sorry, I'm in a public space trying to find my way home. But I think my opinion would be we can just brush through the nitty-gritty of the arbitration process, then especially encourage the mentees. There are a lot of resources, there are a lot of materials they can take advantage of. If you go online, you can watch arbitration sessions. Google is there. So many things you can do. I was actually expecting that since this is like a practical arbitration class, they would have gone ahead before this class to watch some videos, read some practical issues as with touching arbitration. Nevertheless, it's not too late. So mentors can just go through the process again, while we can now give an assignment to the mentees, what link to watch, what we need to do. I wouldn't know if that sounds right, but just a little expression of my thoughts and concerns as touching the issues.
Okay, Nacho, I don't know if there are other mentors, how many of us are here today, but fellow colleagues, mentees, good evening once more. Sorry for joining late because
Good
the
evening.
information reached me as well late, and I was in a meeting. I just had to skip out to quickly listen to what you guys are doing, and I contribute what I can. But when I came in, honestly, what I had ongoing were like some market women trying to negotiate how to buy some tomatoes in the market, and I was immediately texting Natch an inbox that I want to intervene to stop them. We should not sit and watch a totally out of procedure trial being conducted by them, which might help rather derail them. Because at times when people are learning something, in the process of learning, once they start learning the wrong thing, it is possible that that thing might stick. And arbitration is a very professional practice, or private litigation. I hear with one of the brother who wrote that. It is just like a court session. And in a court session, what happens? When the matter is filed to court, either through the counsel or the parties. But if it is a criminal matter, it must go through the prosecutor, because all criminal matters are state matters, unless the case of a private prosecutor. So when that matter is being filed to court, the registrar of the court sits on the matters, ascertain them whether they are first of all triable. If that be the case, then they register the case, assign them case numbers, and then put the case on the course list. The judge, except of matters of interest, in Africa, some matters are matters of interest and they come from different sources. Unless they are matters of interest, but on the normal procedure, the registrar now presents the course list with all the file to the judges or the judge, if it is a panel trial. And the judge sits on the matter, they program a date, lawyers come and pick dates, and when the matter is going to be heard. So lawyers come to court, they address the matter is set for mentioning. The first step is mentioning. You hear a lawyer say, my lord, I'm here for our matter is for mentioning, and so they mention it. If it's a matter that the judge, at his discretion or her discretion, wants the matter to be heard, that same day, then the matter can go ahead. If not, they pick another date of adjournment where they'll come back for hearing. And after hearing, the judge takes down the minutes during the hearing. And if they are calling on witnesses and so on and so forth, that is being done. And at the end of the day, the judge will have to pass, whether it is a ruling or it is a judgment. It all depends on the nature of the claim or the fault. So it is the same like in arbitration. But in arbitration, what do we do? Arbitration, because the arbitrator is not under a seal like the judge, there is no policeman standing by the side. If you enter any court, you see a policeman standing by the side. That shows state authority. The arbitrator can sit anywhere, and arbitration can even take place. Remember I said last time, even in a private jet, in a plane, anywhere, an arbitration can take place. Okay? And when a matter comes up, either through a council or through a company or through a corporation organization or an individual who seeks an institution, for example, you have CIAP, you have KIAC, you have ICC, you have LEAC, that's the London, you have IAC, the American. There are different arbitration institutions around the world. If it is ad hoc means one-on-one. Though there are some institutions administering ad hoc arbitration, means that the institution might just appoint one arbitrator to sit. But most institutional arbitrations are mostly panel. They are mostly panel tribunals. That is to say, they appoint 3 arbitrators. Usually it is 2. One from the claimant, the other one from the respondent, and then the 2 arbitrators appoint the 3rd person who sits as the chairman or the president of the tribunal. I don't know if you have all these stages. I don't know if among yourself you respected these stages to appoint your arbitrators. I don't know. And now, when the panel sits for the first PI, they call it the preliminary hearing, while in court they call it preliminary investigation. When they sit, that's where they agree on certain terms, the arbitrator's terms of reference. Before you, the arbitrator, once you are appointed, you confirm your appointment, you declare availability, and you declare your conflict of interest. Whether you have conflict of interest in that matter, you also declare your availability. And sometimes fees of the arbitrator is determined by the arbitrator himself or herself or the panel. Sometimes fees are determined by the institution. The institution already has a rate that they calculate per the amount of dollars in the matter as a claim. Now, when the arbitrator has accepted to arbitrate, has accepted the appointment, they send their terms of reference to the parties or the parties' counsel in that arbitration. After that is done, the counsel will do what? They will respond. So after they have responded and confirmed the arbitrator's declaration of conflict of interest, he or she has no conflict of interest in the matter, they are all set and good to go. The arbitrator now, or the parties, especially if they have big claims, they need a tribunal secretary. A tribunal secretary can be appointed by the panel, the tribunal, or the institution that is administering that arbitration. For example, I will be sitting, they just asked me to submit my CV. I'll be sitting as a registrar for the panel tribunal secretary for one arbitration that is coming up. The matter So in this arbitration now, the parties had their preliminary hearing last week. It was an online arbitration. And due to the nature of the claim, the panel needs a tribunal secretary. And 3 of us were requested to send our CVs, and my CV was selected among the CVs. So those are preliminary steps or preliminary procedures that you must do as mentees. If you have not done so, you have to go back, prepare in your group, make sure you follow all these steps. That's the first phase. Now, the second phase, there's something they call the procedural orders. In arbitration, we talk about procedural orders. In litigation, we talk about court processes. Okay, we talk about court processes. If you're with me, you are hearing me 5 on 5, you can drop a comment in the comment section, please. So let me not be speaking to myself. Are you hearing me? Nacha? Okay, all right, Ephraim, thank you. Thank you. So,
Sure.
okay, thank you. So after the preliminary meetings have taken place, the need for a secretary, tribunal secretary is needed. The need for expert witnesses are needed. The need for might be observers are needed. The need for invigilators, because they are also invigilators in arbitration. What is their role? They monitor witnesses, because some witnesses are very malicious. So these are the different roles and opportunities you can have in an arbitration procedure. After every party involved or the actors involved in that arbitration has been confirmed, now the arbitrators or the arbitrator sends out a procedural order. That is a terminology you have to go and read. I would not tell you today what is a procedural order, else I'll be doing your work. As a mentee, you should be able to show us what you have learned, what you can capture, and then we'll assist you from there. After the procedural order, the counsel or the parties have to reply, depending on what is in the procedural order. It can be procedural order number 1. In arbitration, you can have even up to procedural orders number 10, 1 to 10, 1 to 5, 1 to 3, 1 to 2. Just depend on the nature of the arbitration, how complex it is, parties involved, especially in international arbitration with multinational companies and so on and so forth. But this claim, I just read this your case scenario briefly. I think it's just 20,000 naira. It's a little sum. So it's not a complex arbitration. There can be some arbitration with little sum, but the facts are complex. So as an arbitrator, what do you do when you are faced with a claim? You have to separate the facts from the contract. You have to separate the facts of the case from the contract. You know that the contract is backed by law, a particular law from which that contract is born. You have to make sure that first of all, you check if it is arbitrable, because there are some matters that are not arbitrable. If it is arbitrable, good. You check the law of the seat. You check the rules of that institution that is administering that arbitration. For example, if it is Kigali International Arbitration Center, you check their rules 2012. If it is ICC, you check the ICC rules and the regulations. If it is American Arbitration Center, you check. If it is LAAC, London Court of Arbitration, you check their rules. It's the same thing as a lawyer. You go to any court, you have to check the rules of that court. So you see the similarity between the procedures. Having checked the rules and everything, you now, if all facts being equal, you now convene hearing. If there is no preliminary matter to be sorted out, you can convene your preliminary hearing. If there is a preliminary matter to sort out, you can do that, or the institution can do that through what is called emergency arbitration. But remember that sometimes orders of emergency arbitration are not binding to the tribunal when the tribunal is formed, if it's properly composed. So when that is done, now the arbitrators or the panel sits, and that is where parties come. It can be either acquisitorial or inquisitorial, but practically it is good to let it be acquisitorial. That is, say, like the common law system, like the common law way of presenting or making submissions, presenting your case before the court. Parties, and you remember, time in arbitration is something very essential, which it can even lead to the setting aside of their word. You have to give equal time to the parties. If you give the claimant 20 minutes to present their case, you must give the respondent 20 minutes to present their case. Sometimes when they give you scenarios, do not bother much at reaching an outcome. Bother and get interested in the procedure. I've sat as arbitrator or judge on so many competitions. Recently, I sat one on the American Bar Association. Those students are those white skin, permit me say so. They are very intelligent, very smart students from the university. I'm telling you, I enjoyed their presentations in their competitions. You have different teams coming, and all are very tough teams. Sometimes as a judge, you don't even know how to judge them. But you just have to make sure you follow the procedures, the team that really follow all the procedures, and that's where you can make the difference. This is just a reference I'm telling you. So that your claimant, you are the one claiming, so you should prepare your claim very well. You come and present your claim before the tribunal. And you have to concentrate more on the real facts, what you want in the claim, especially your prayer. We call it in court the prayers. You pray the court to do this, do that, do that, do that. As well, you pray the tribunal to do this, do that. If you are there with your counsel also speaks. Most times, some people allow their counsel to speak on their behalf. Some companies, some organizations. When the claimant has presented their case, the respondent will come and present their case. That time, the arbitrators are taking down notes because they had already read through the claim. They have already put the facts with the law to see what is there. And then this conscience now comes in as the third aspect of the arbitrator in deciding over an arbitration. To make sure that you don't have any conflict of interest over taking a decision in their word. Because, like I said the last time, an arbitrator should not be known for his awards or her awards being set aside. You lost credibility, because this is a profession that goes a lot with credibility. So when you plead, you make the submissions, and then At the end of the day, if there are witnesses, the panel will call the witnesses. Witnesses will come, they will examine them as well, the way they examine witnesses in court. After having been examined, the arbitrators are taking their notes, just like the judge is taking her note or his notes in court. And at the end of that pleading, that session, that proceeding or that hearing, the arbitrators recess. Award should not take more than 90 days. Most of the rules, the institutional rules, being born from the UNCITRAL arbitration rules, they don't take more than 90 days for the award to be rendered. But if you can write your award within 30 days, you are a perfect arbitrator. People will always sort you, institutions will always appoint you because they know you are an apt arbitrator. You don't waste clients' time, because when we say arbitration is quick and faster than litigation, these are all the things we have to curb: timing. But maximum is 90 days. So the arbitrators now write their award. The three arbitrators, when it's a panel, usually is the president who writes the final award. The arbitrator 1, arbitrator 2, they will send an extract of their own decision. Sometimes you may find a dissenting award because maybe two arbitrators agreed on something different and the third one agreed on something different. That's where dissenting award comes from. Or in court, we call it dissenting opinion. It is minuted in the explanation of the award. Every award has an Hello, Nachan, you muted me. Hello?
We can hear you, Ma. We can hear you, Ma.
Okay, all right, okay. So, in the explanatory section or the explanation section of the award, if there is any dissenting extract or dissenting views of a member of the panel, that will be minuted in the explanation section of the award. And then when the award has been written, drafted, it's been sent back to the institution. If it is an institutional award, it's been sent to the institution, where the institution, through its Secretary General, goes through the award. He or she vets the award. He or she vets the award to make sure that the award is equal to standard. The award is equal to international norms and standards. That award can stand the test of time before any international court or before any tribunal. I don't know, I gave you people the case of Nigeria versus P&ID. I don't know if you people read that award. If you have read that award, put it in the comment section that you read the award. If you've read the award of Nigeria versus P&ID, this was what I told you people last session to read. If you have read that award, put it here in the comment section, in the chat. If you haven't read that award, then you are not a serious mentee. And sometimes it becomes boring to mentor people who doesn't make efforts. Some of us did not have these mentorship sessions when we started. So if you haven't read it, I'm still giving you the second chance. Go and get Nacha, I'm not in their group. I can send the award. I don't know if you have that award, Nacha. I'll send it to you on WhatsApp. You share with them. It is a must. It is a compulsory. That is today a secular case everybody uses for reference in arbitration today. Because it has virtually all the caprices of an arbitration process and an award. Nigeria versus P&ID case. So please endeavor to go and read it. I'll send it to Nacha. Nacha will share with you all. Now, if the secretary of the institution has vetted the award and the award is okay, they have to send the award to the parties forward for execution. Now, this is where the seats of the arbitration comes into play. Very, very important. When they take the award, they have to go to the court. This is where the New York Convention 1958 comes on. An exequatur. That award is just considered like an exequatur. An exequatur is a judgment rendered in a foreign court that is to be executed in another country. When that judgment comes, it has to be registered into the court. It is put the enforcement formula or the seal, and then it is now being executed as an exequatur. So that award goes through the same procedure. Because remember, the obligations in the award deal with people's property rights, and it is a state obligation to protect people's property rights. Investors invest in a country. One of the things they check is property rights, how their properties can be protected. Okay, so the law of the seat plays at this point in the enforcement of that award. When it comes, the registrar will register the award. They will notify the judge of the award. And it falls also on the court's list like other things matters, but now it is enforcement only. And then the judge will go through the award. If the award is against the reasons for no recognition, might be public policy, might be due process, or there was no fair hearing, all those kind of things. They look at it, and if the award is to be set aside, they will put the set aside judgment. If it will not be set aside, the award is being validated by the court, and it goes for execution. The bailies, they now go for execution. So that is actually an arbitration procedure. If you didn't find yourself within these procedures, and what my colleagues will also add, or what some of them have said before, please try to find yourself within the procedure I've given might not be 100%, but I have virtually given you all the basics that needs to be in an arbitration procedure. And different arbitrators now might have their arbitration style to make it different, to modernize it or make something, but those are the preliminaries and the basics in arbitration procedure. So I think I have helped you. You have to go back, reconvene yourself, and you do the right thing. And so that in the next session, we will be able to sit and really watch like good observers and make just some few comments. Thank you very much.
Thank you. Thank you. We appreciate you.
Thank you very much, Ma, for that. Okay, Mr. Yacham, Mr. Yacham, are you with us, sir?
Yeah. So thank you very much for that wonderful contribution. Mr. Samuel, is Mr.
Yes,
Samuel
please.
with us? Okay,
Yes,
so
please.
please, Baratu, are you with us? Okay, so Mr. Samuel, go first before Baratu. Miss Pa, you have done a wonderful job. You have summarized the whole procedure from the beginning to the end. And I believe that when the mentees are able to use the guide you gave them to make research, they will understand better, and I know they will do wonderfully well. Thank you.
You're welcome. You're welcome. Welcome. Thank you to everybody.
Meanwhile, if you have questions, you can take notes, you can drop it on the chat box, and you may ask it later on. But please, just listen to the mentees. I pray that you have opportunity to do a presentation where mentees will be available to make their input.
Thank you, Mr. Nachang. Good morning, good afternoon, good evening to all present. Let me especially appreciate our highly revered mentor for that exhaustive explanation. Thank you so much. We appreciate you. And to the mentees on board, I am sure you will discover that the tone has changed a little bit. The tone when we're doing mediation and now arbitration, the tone has changed. The tempo is not as slow as it was during the mediation. And I'm sure you will agree with me that arbitration is a much more rigid process when compared to mediation. Like the last mentor said, we must have been exposed to arbitration clause or arbitration agreement when parties have contractual relationship, they must have decided on their own to put up what we call an ADR clause, stating the ADR mechanism that they will choose to explore in the event of dispute. So let's assume that the parties agree that they are going to explore arbitration in the eventuality that there's a dispute and a dispute does occur. In the arbitration clause, they must have agreed the law that will govern the process. They must have agreed the number of arbitrators that will be involved in the process. While we were using the ACA, the Arbitration and Conciliation Act, when the agreement does not indicate if it does not indicate the number of arbitrators, the default number is 3. But under the Arbitration and Mediation Act 2023, where the arbitration clause or agreement is silent as touching the number of arbitrators, the default number is 1. It therefore means that a single arbitrator known as a sole arbitrator can oversee the process, can oversee an arbitral process, while an arbitral panel made up of 3 arbitrators can oversee an arbitral process. How does it begin? If it is a sole arbitrator, a party to the dispute can write to the other party in signifying interest to activate the arbitration clause or arbitration agreement that they have entered into. And upon notifying the arbitrator then informs the parties, both of them, on the need to convey what we have had, the preliminary hearing. This is usually the first official meeting between the arbitrator, the arbitral panel, and the parties. If it is a complex matter, there may be the need to have a registrar and a secretary. In some cases, an individual may play the role of secretary and registrar. The role of the secretary and the registrar is to oversee the secretariat of the arbitral tribunal. What do? They assist in documentations, exchange of documents, delivery of documents, taking down minutes and notes during the arbitration process. So when parties are getting ready for the preliminary hearing, the arbitrator, through the registrar or the secretary, writes to the parties, informing them of the dates, informing them of the time, informing them of the venue that the preliminary hearing will hold. And they'll be encouraged to come with the documents, the primary contract, the arbitral clause or the arbitral agreement, and any other document that relates to the arbitral process. If it's between an individual and a company or between 2 companies, the identity of the person that will be represented in these companies must be clearly identified. and document in form of letters authorizing them as stating the capacity in which they will be making representation. One of the arbitral process I was privy to be a part of, one of the party, an institution, on the date before the preliminary hearing, notified us that they have assigned one of their staff to make representation for them and observe the process. We were quick to let him know that whoever is coming from your end, it's not just to come as an observer, it's not just to come to see what is going to happen, but that person must come in the capacity to sign and enter into agreement, and whatsoever the person says or sign will be binding on the company or the establishment or the institution as the case will be. The same way we have pre-session in a mediation setting, that is also how we have preliminary hearings in an arbitration setting. Here, everything that has to do with the process is agreed upon. The language is agreed upon. The mode of hearing. An arbitral process can be based on documents only. An arbitral process can be based on hearings only. An arbitral process can be a blend of both documents and hearing. When I say documents only, what do I mean? Parties can agree to save time and to save stress to make submissions of documents that will give more light concerning their position to the arbitrator, to the arbitral panel. No hearing, no testifying, solely documents. And based on the conclusion drawn from those documents, the arbitrator or the arbitral panel can proceed to make an award. It may be agreed at the preliminary hearings that the process will be both documents and hearings. In other words, documents will be submitted and hearings will be heard. They can also agree that it is going to be based on hearings alone. Also, during the preliminary hearings, the fee for the process will be discussed. And don't forget that the persons that were appointed by the parties are actually the arbitrator or arbitrators in the case of an arbitral panel, like we had earlier. If it's an arbitral panel, each party appoints an arbitrator each, and these two arbitrators that have been appointed, we appoint a third arbitrator. In our claim, the third arbitrator is called the arbitral chairman. He oversees the process, and usually the arbitral panel may pick an individual, a certified person, to be made to function in the capacity of registrar, secretary, or two in one. At the preliminary hearings, the arbitrator or the arbitral panel present the person that have been appointed or selected, let me use the word selected or nominated, to act in the capacity of a registrar or a secretary. And upon confirmation by the parties, that appointment sticks. So everything that has to do with the process is agreed upon at the preliminary hearing. And when that is done, the fees are agreed upon. Usually, like we had, it is either institutional, being overseen by an arbitral institute, or ad hoc, when the parties engage the arbitrators on a personal basis. The fees for the process is usually a function of the nature of the case, just as we spoke about much earlier in mediation matters. In some cases, the fees are negotiable, and upon coming to a common ground, the date for the commencement of the arbitral process is agreed upon. I will try as much as possible not to touch some of the areas that have been explained. And when the preliminary meeting ends, it will also be agreed the mode of documentation. Usually, after every sitting, after every arbitral sitting, it is the duty of the secretariat to make available to the arbitrators a summary of the process. It will be agreed if they need some kind of equipment, if they need a specialist to help in documentation, everything will be agreed upon. And when they are done, the arbitral panel will issue procedural order. Like we said, it could be 1, 2, 3, as the case may be. Procedural order contains information as the position of the arbitral panel in as touching the matters, how it's going to go, the fees, the date for submission of point of claims. In mediation, the claimant submit statement of issues, but in arbitration, the claimant submit points of claims, the date for the submission of point of claims, the number of the copies to be submitted, through whom it will be submitted. All this information are contained in the procedural order, and the arbitral panel may also deem it fit to state the account details that the parties are to make payments to, and it will also be agreed the mode of payment are parties to pay 50% of the entire cost at a certain date and make the balance payment at a further date, or with the full payment be made. So the mode of payment and the channel of payment will be agreed upon and communicated to the parties in the procedural order. And if there's any change or modifications that comes in the arbitral process, procedural orders is usually issued from the arbitral panel through the arbitral secretariat to the parties. I must say this, in practice, when documents are being served, if you serve one party through a particular means, it is due diligence to serve the other parties through the same means, and documents being served should be endorsed and acknowledged for the purpose of posterity. Now, why the matter goes on, if each party have weaknesses, they can call in their weaknesses. They must have agreed as touching the number of weaknesses that will be entertained in the process. The timing for the respondent to submit their points of defense is also stated, and the respondent is also free to turn in their counterclaim. They may choose not to reply to the issues as stated in the point of defense for the claimant. They may choose to raise other issues that sort of reflect their position on the matter. Don't forget, in arbitration, it does not take so much time. People call it private litigation. It is the duty of the arbitral panel or the sole arbitrator to make up his mind and take a position on the subject matter. The end point of an arbitral process is the award, as we all know. And when writing an award, it's usually dated, the names of the arbitral panel, the name of the arbitrator is there, the issues that were deliberated upon, no matter the number they are, and the position of the arbitrator, if it's a sole arbitrator, or the position of the arbitral panel is usually being expressed as touching each of the matters, and a final position is usually being stated. Not just the position of the arbitrator or arbitral panel, the reason why that decision was made is also stated. In the case of an arbitral panel where we have three arbitrators, the arbitral chairman and the co-arbitrators, it is not a must that they must agree as touching a single opinion. If two of the arbitrators have a similar position and the third arbitrator has his different position, it is fine and good. Two arbitrators may end up signing the award, and if the third arbitrator refuses to sign the award, the reason why he doesn't sign it will be stated. We all know when you are exposed to practice, you begin to understand all that it takes. I'm glad that we have several arbitral institutes, and Settlement House ADR Training Center is home to diverse spectrums in ADR. They are into arbitration, into mediation, into negotiation, into restorative justice, just to mention a few. And you can partner with these institutes to have first-hand practical information, no matter what you're exposed to in trainings. There's nothing like having practical experience as touching ADR mechanisms. We all do know that ADR are confidential processes, but through mentorship scheme, through volunteering, through making yourselves available, through looking for creative ways to hone your skills, you can you can get an opportunity to begin from somewhere in your journey as an arbitrator. Having said that, there's much more to know. Take advantage of the social media in the positive light. Get connected to a whole lot of things. Watch live sessions and look for those that you can tag with as mentors as a journey in the progress. The ADR world is a world of endless possibilities, and we do look forward to seeing you in the shortest possible time, making significant impact in the ADR world. Thank you for giving me your audience, and I do hope within the short time I have been able to throw a little light, contributing just a little to what our mentor has said as touching the ADR process known as arbitration. It is private litigation and much more rigid than mediation, where an award is given which may likely favor one party and may not favor the other party. We know that awards cannot be appealed. At best, there's an application to set it aside. And with the provision of the Arbitration and Mediation Act 2023, there's provision for the Arbitral Review Tribunal, a provision that is optional. Parties that are not too satisfied with the outcome of an award may decide to appeal to a panel to look into it again. Whichever way it is, one party must end up smiling at the end of the day. The worst that can happen is for an application to set aside an award. And before an award can be set aside, it must be on the fact that the arbitrator, when they were going through the process, were unethical in their conduct. We take arbitration seriously because you do not want your effort at the end of the day to be thwarted. Because when you do well, as we have heard much earlier, in a particular process, the chances that you get more process is there. Finally, arbitral processes are to a large extent usually more expensive than other forms of ADR processes, but it is usually a reflection of the nature of the case. Thank you, thank you, thank you. Over to you, Mr. Nachan.
Thank you very much, sir, for that wonderful contribution. So, Miss Baratu, are you well with us? Mr. Samuel has done wonderfully well. I believe that the mentees are listening. Ms. Baratu?
Yes, Mr. Nanchan, good evening.
Good evening, please.
All right. I'd like to appreciate the mentors who have given a lot of insight on the practical aspect of arbitration. And in our simulation for today, we have two sides of the story, which is the claim side. Now, the usual thing to begin Mr. Musa here supposedly ought to have sent a notice of dispute to the respondent, which is the A and B company. And perhaps in the arbitration agreement, even though it is not clear there, let me say they are using a sole arbitrator. And once that sole arbitrator is appointed, there are things that the sole arbitrator needs to do, which have also been mentioned by my co-mentors. Especially the first mentor gave a detailed explanation of what the arbitrator should do, the point of disclosure, and other things. Confirm your availability if you can do the arbitration, because it won't be good for you to take an arbitration without you performing the task and within the time that is stipulated. Now, of course, my co-mentors have also mentioned the processes, which is the first thing that is done in arbitration is to have a preliminary hearing or a preliminary meeting. Now, in that preliminary meeting, the agenda for the arbitration from the beginning to the end of it is usually set. So you, as a complainant, would have known that by the end of 3 months, I will have my arbitral award. Or by the end of 2 months, I will have an award in respect of my complaint. So what are the things that are usually discussed at that preliminary meeting? Number one, the parties are told or are invited to attend the preliminary meeting. And the first thing to be discussed at that preliminary meeting is the parties introduce themselves and their respective counsels. Now, in the simulation that was given by our mentees, even though it was more of a mediation than an arbitration, at a point, one party was saying he is the party. At a point, the party was saying he is the counsel. So there must be a clarity between the parties and their representatives, and then possibly the counsels representing either the claimant or the respondent or the defendant, as it were. Now, the next thing that should be done as part of the agenda for the preliminary hearing is the introduction of the arbitrators themselves. And then, if it is a panel of arbitrators, all the members of the panel are introduced at that preliminary hearing. And then the next thing in the agenda for that preliminary hearing is to adopt the provision of the agenda. That is, what are we doing? How many days are we given for each step that we are going to take in concluding the arbitral process? Now, the next thing that should be decided, which is number 4, is to determine the venue. The venue, where are we going to sit to do the arbitration? That is the venue. And then what are the applicable rules? Part of this has been discussed by my co-mentors, whether it is ad hoc rules or it's institutional rules. This will be agreed at the arbitration preliminary hearing. And then the next thing that should be looked at after looking at the determining the venue should be very conducive. It should be peaceful. It should be a place where the claimants, the parties in the arbitration will feel very comfortable to ventilate their grievances and to also find a solution. And it should also be conducive for the tribunal itself. So the next thing, after determining the venue and the rules that will be applicable in the arbitration, is appointment of registrars for secretaries.
Is there a reason why we can't see your face?
I'm afraid of my network because my network has been having issues actually. So my video is on, my light is very poor, and my network has been very poor as well.
It's all right. Go ahead.
Yes, you can see that I've on the video, but I can't even see myself.
Go ahead.
So can I? All right. Thank you very much. So the next thing that should be looked at the preliminary hearing is, like I said, the appointment of the secretaries. That is those who are going to assist the tribunal in ensuring that the documents that will be used for the arbitration process are kept. And even the secretary's responsibility is also to ensure that the venue of the arbitration is conducive. Everything that is needed for the arbitration is there, and it is there when it is needed. So the next thing that will be discussed as part of the agenda for the preliminary hearing, as also already said by my co-mentors, is the remuneration for the arbitrators and even the registrars or the secretaries. Usually the parties share the cost of arbitration. Half of the cost will be borne by the claimant, half of the cost will be borne by the defendant or the respondent. It is at that preliminary hearing that this issue
Hello.
that point of part of what will form the point of claim. And then the next thing we will look at is after he has filed or the claimant has filed points of claim, time is agreed at that preliminary hearing that the defendant will file his point of defense in 10 days or in 5 days or in 3 days, because arbitration is time bound. So the defendant files his point of defense and then states a defense against what the claimant have stated. Now, in the simulation before us today, the defense of the defendant can be supposedly that the claimant did not work for those 8 months, so he is not entitled to be paid. And then another defense reach out when he realized that he was not given any job with defense. So the points of defense are filed, and at that preliminary hearing, also to file a refer filed. And perhaps in the simulation we have even didn't send a message employed ability employers you can't employ somebody and leave him. You have to give him work. And to reply that he actually made effort to reach out to the company, but he it is not orally to be stated. It must be a document. Now, it is also at that scheduling and the pleadings that the parties will agree, oh, the claimant will bring 2 witnesses, and who are these witnesses? Or the defendant will bring 10 witnesses, and who are these witnesses? And then at that preliminary meeting, it will also be agreed, how will they give their testimony? Are they going to give their testimony in writing, or they are going to give their testimony orally? It is at that preliminary hearing that parties will agree, oh, perhaps we are not going to bring witnesses. We are only going to decide based on documents. There is documents that the claimant has, his letter of employment, confirming his employment, and the fact that he is meant to be paid. And then the claimant, the defendant or the respondent can also give his own defense, or to say, oh, we are going to use only documents to show that we tried reaching out to him. We sent him different emails, but as if he was not checking his emails, which is why he didn't know that he was given certain responsibility and he never gets to do them. Then the next thing is, what is the mode of communication in the arbitration? How are we going to be communicating to the claimants and the respondents? Are we going to be sending them emails, or we are going to be sending them communication by post? Perhaps we will use DHL or EMS Express or whatever. That agenda, that should form part of the agenda at the preliminary hearing. And that should also form part of what will be discussed at that preliminary hearing. Parties will agree at that preliminary hearing. And then another thing is there any application for injunction, maybe before the end or before the final arbitral award is given? There could be need to save some things. Maybe it is a perishable goods, but in the simulation before us, there isn't anything perishable. So perhaps there may not be any need for interim injunction. But interim injunction is one of the things that should be decided at preliminary hearing. And then any other business. And then adjournment will also be decided. What date are we adjourning the next session? Because the preliminary hearing becomes the next session. And after that preliminary hearing, whatever is the decision at that preliminary hearing becomes an order for direction. And parties are sent the report of what happened at that preliminary hearing. It becomes an order on all the parties that they must comply with, that they must abide by. And that is why the next sessions of arbitration becomes easier, because the preliminary hearing and the agenda for the arbitration has been set right from the very beginning. And so after setting the arbitration into motion by doing the preliminary hearing, the last agenda, which is adjournment, will give the party an idea of the next time they are coming. And then remember, the venue has already been decided. So this time around, the next time they are coming, they know that we are coming to a particular venue. And also, every other person who has responsibility knows that perhaps maybe the claimant who has to file a point of claim knows that I'm filing my point of claim from today in the next 3 days or in the next 4 days. And then the defendant who is filing a point of defense knows that I'm come to the message to the arbitrator to file a document, given reason why he was not able or why she was not able to file within time. But all of this must be done within the complete time that has been agreed at the preliminary hearing. And during the hearing is usually done like a normal court hearing. That is, the defendant has the right to cross-examine perhaps if the claim is witness. Then also, Bali agreed, are we going is not bound to maybe we a public certificate. Parties can agree, no. Of evidence, it is a preliminary hearing that parties agreed on that. Now, at the end of the arbitral process, the arbitrator is to be neutral in all of this. Usually during the hearing, if the arbitrator has any as it was presented today, you see the arbitrator it is so in arbitration is neutral. At least arbitrator considers confirms Mr. Musa against A and B company. If that is his finding, then the stated. So I don't want to go into details of that. But at the end of arbitral award, and we have been taught what should be contained there and what should not be contained there. So for now, I will want to stop because I can see the time has is fast spent, and maybe moving forward for our mentees, they can, like our other mentors said, go ahead and do in-depth research and find out what are the practical things that are done in the arbitration proceedings. Thank you very much for this opportunity to JIIPC, and thank you also very much to the wonderful mentees. I could see them, they are actually eager, and I'm sure they will do very well as arbitrators and mediators and ADR practitioners moving forward. And thank you to Settlement House Institute for this great opportunity to serve as a mentor. Thank you very much. Thank you.
All right.
Thank
Thank you very much, Baratu, for that wonderful contribution. Now, ordinarily, this could have been the end of the mentorship today, but the parties have not done what they ought to. I believe that in mediation, they can say that they have a test and experience of what being a mediator, a party is, because they participated. But now, the aim of having a mentorship that is total mediation, arbitration altogether, is to give someone a balanced, way of, a balanced knowledge of what has been taught. You see most of the mentors that came in, most of them are both mediators and arbitrators. So in as much as you can just be a mentor, you can just be a mediator, you can as well be an arbitrator, and you can join the two and you can practice the way I do. I practice in all the mechanisms, whether I'm a negotiator, I'm a mediator, and I'm an arbitrator, I'm an ADR registrar, just name it, all of them, so you can be all of these things at the same time. So, Dennis, Sophie.
Yes, sir.
Okay, so
We can hear you, sir.
now, so I don't know what we will do. What do you advise we do at this juncture? Because due to the circumstance.
All right, sir. Considering that we may still have to have the simulation, right? I think it's okay if maybe we set like private a more private simulation program where we can just have our mentees come and present their simulation on arbitration, and then we'll just have mentors comments. Maybe not like in this kind of setting, because this is supposed to be the official last class for the arbitration for ADR. The subsequent classes are going to be combined classes. So I think we can still discuss on that and see maybe if a later date, let's say Wednesday next week, will be convenient to have that simulation. We can just tell the mentees to go and prepare, have their simulation, and just have comments from the mentors. Would that be okay by you, sir?
Okay, so maybe we'll have this conversation and see, because our intention was we wanted to see if we can get a platform where mentees who successfully completed this training can be able to have opportunity to become certified mediators or arbitrators with Settlement House ADR Training Institute. And I was watching the attitude of the mentees. To some extent, they have tried, but some of the attitudes are not encouraging, especially by the end of the like last time, by the end of the meeting, you see just few 4 5 people online, and that attitude is really, really discouraging. So I'm hoping that we're going to conclude on that, so that those who are interested in becoming certified, we will see what can the kind of opportunity and maybe discounts that will be made available for them to take advantage on. So but we need to see people who are willing. It's not something that people who are given opportunity, they have not taken that opportunity seriously, and then another one will be given to them. That will not actually be good. So we're expecting that perhaps if we're able to agree that we're going to have you come back again for the simulation, then I believe that you should do the needful, so that you have a very robust session that you yourself will be excited. During the course of the explanation by the mentors, you can see how colorful the session would have been if you are the one doing it by yourself, and then corrections comes here and there. It would have been wonderful. Your knowledge and your mentorship would have been complete. The intention would have been achieved. But this is being thwarted. I pray that the management will be able to be gracious enough to extend the opportunity. So maybe we can also hear from one or two persons from the group. If such opportunity is extended, is it possible for them to take advantage of that opportunity and do the needful? Or let us not waste our time, because look at the mentors are here with you, sacrificing their time, not just 1 hour or 2 hours thereabout, just to come, stay, listen to you and mentor and give you the best, but you yourself, you are not available. That is not something that is encouraging. Seriously, if you are to be charged for what you are learning or you are gaining, I know that most of us will not be available, because you may not be able to assess what you are going to gain, so you may not want to spend much on it. but this is something that is you should actually cherish with the whole of your heart and do what you need to do. So if we're able to arrive at that, that would be good. So I don't know if we have some mentees that will make one or two comments before we call it a day. Okay,
Okay,
Augustine.
Mr. Augustine, you can go ahead.
Okay, good evening, sir. First of all, I'm Augustine Chima, and I want to apologize for our attitude
We
towards
cannot see you, Mr. Augustine. Can you on your camera? Let's know who is talking.
It's dark here, sir. Well,
Okay.
I will turn it on. My face can't show well. It's dark here. Can you hear me, sir?
Please go ahead.
Okay. Okay, so I want to first of all apologize for our bad attitude towards the mentorship training and the way we react to the tasks given to us. I know that most of us that we are new to what ADR talks about, and I can remember the last training we had on mediation and the practicals, how the meetings we had in group one to make sure we come up with something, going to YouTube to watch videos and know how we can go about it. Even we tried in this arbitration and we could only come up with the presentation that what we presented today. But in as much as it wasn't satisfying, I want to apologize on behalf of other members of the group and also group two. Also, I want to really appreciate you all for your time, the mentors for your time, and the knowledge you are passing to us. Most of us that are really interested in ADR, like me myself, I'm so much interested in ADR. I've registered over here in Ebonyi State to be certified here. I've made the payment, and then we're waiting for the date for the training, because this is actually the area I want to specialize on. And I'm open to, even if registering or going for further seminars and training, I'm open for such opportunity, because I'm really interested in everything that has to do with ADR. And lastly, I really want to say thank you so much for your time. It's not easy to bring out 3 hours of your time every Wednesday to teach us, guide us, and mentor us. So I will be the very best of ourselves. Thank you so much, sir. I really appreciate it.
Uh, Gloria, please, we also like to hear from you. Gloria, we want to hear from you. Your hand is raised.
Yes, sir. I want to say in a more special way, on behalf of my group and our mentees, and I want to say thank you so very much to all our mentors. It's been so wonderful, bringing out all your time and efforts despite our seeming unseriousness, even when, I know most of us, we are really trying our best, but even though our best does not seem good enough, we are so sorry. I want to say sorry for disappointing you today. Please, as you want to give us another opportunity, we will never take it for granted. We really appreciate it, and we'll come out better. And the way you really love it, please. We appreciate this opportunity, this second chance you're giving us again. I want to say thank you, so please. Thank you so very much. Thank you.
Mr. Samuel, you
Yeah,
want to say something?
permit me to just say this and now that we actually appreciate every one of you, in as much as it's not easy for mentors to dedicate their time. We also know it's not easy for mentees to also dedicate their time. Because we have your interest, your best interest at the heart, we are making these remarks just to propel you to move forward. Like I said much earlier, the tone of mediation is a bit different from the tone of arbitration. Arbitration is much more business-like. We do not take your inputs for granted. We do not take your efforts for granted. But we believe that you can be spurred to a greater height, even as you put your passion to life. So thank you. If we've made you feel bad in any way, we apologize, but we do know that that was just a push to make you go out because we know that you can do much more than that which has been done. So I thank you, I thank you, and I thank you. And I know with each attempt, the result will be better. We appreciate you. Don't feel bad. We are all in the process together and we will always get there. Thank you so much. Thank you.
Okay, so is there any other question? Okay. All right. So, Mr. Dennis.
Okay, sir. So I would just like to still encourage the mentees to further facilitate group discussions among yourself ahead so that we can have the simulation come next week. I will still discuss, or we, the management of JIIPC, will still discuss with Settlement House, Mr. Nyasham, to see if that will be possible for the class or for a simulation, for the simulation practicals to still hold next week. Further details will be passed across to the members of the group through the WhatsApp platform. If there is any need for any readjustments or realignments, it will be also communicated to the group. Once again, want to say thank you to our mentors and thank you to our mentees for being in class up to this moment. We thank you to the mentors for their feedback on what the mentees were scruffully able to put up together. Please, we encourage our mentees to please take what we are doing beneficial. It's going to be very beneficial if we all put in the effort. And with this, we've come to the end of today's session. Nice having everyone in class. It's been nice having Mr. Samuel,